Attorney Jeff Roberts briefs us on the facts of a negligent entrustment case where a driver with 2 previous drunk driving arrests and a suspended license caused the death of a pedestrian.
Through the course of his employment, Mr. Delgado moved up positions, became a service technician for Xerox, both an independent service technician in the sense that he would drive to various business locations and repair and service Xerox equipment, and then later he became what was called a managed service employee, where Xerox has an account at a particular location, and then they have designated service personnel that work at that account. And so Mr. Delgado eventually began working for one of Xerox's managed service accounts. That account was a fairly large account called Long Beach Memorial Medical Center in California, and there was a vehicle assigned, or a vehicle provided to that account site, and this is called a managed service vehicle. That's the designation Xerox gives it. And that vehicle was a Ford or E150 van, and Mr. Delgado was permitted to drive it. In fact, he was required to drive it to accomplish his job duties. Now, that was the case all the way through April of 2009. When on April 30th of 2009, Mr. Delgado was at the end of his shift, he took the van home with him with the expectation that the next day he would pick up supplies and materials from a remote location and drive it to back to the managed service account. What happened on that evening was Mr. Delgado went and drank alcohol. He then took the van and as he was proceeding to go home, he failed to see Elvira Gomez walking in a crosswalk outside of a Catholic church in Los Angeles. As she was crossing in a lit crosswalk with flashing lights, Mr. Delgado struck her while driving the Xerox van. It knocked her to the ground, causing her severe head injuries, which she died from 2 weeks later. Now, what we learned shortly after the death of Ms. Gomez was that Mr. Delgado received a DUI in October of 2000 with a blood alcohol of 0.24. That's 3 times the legal limit in California. He was working for Xerox at that time. He had authorized Xerox at that time to access his motor vehicle record anytime, but apparently they never did. 7 years later, in May of 2007, Mr. Delgado is again convicted of DUI, his second DUI. 0.24 alcohol, again, 3 times the legal limit. His license was suspended for 2 years at that time. Mr. Delgado continued to work for Xerox, and he continued to drive their van, and he continued to do job duties that required him to drive the van. Xerox never checked his driver's license status. They never pulled his motor vehicle record for 2 full years. Had they done it at any time, they would have discovered he had a suspended license, they would have discovered 2 prior DUIs, and per Xerox's own policies, they would have either terminated him, put him into a treatment program, or at the very minimum, ceased having him do any job that required him to drive. They did none of the above. And it must also be stated that Xerox had a written policy that said that they would periodically check the motor vehicle records of their ongoing employees. And Xerox's fleet manager, Paula Morrissey, testified that by periodically, she and Xerox meant that they would check it at a minimum of 1 time per year or more. And they decided to use the word periodically to give themselves the freedom to check it more often. But guess what? They never checked it, not even once. And this is what happened. A preventable accident. First and foremost, what Xerox could have done to prevent this, and what gives rise to their liability for negligent entrustment. negligent retention of the employee and negligent supervision of that employee is they could have checked his motor vehicle record. They had authorization to do so. They could have at any time pulled his driver's license, or what they call the motor vehicle record, from the California DMV, and they would have learned of his 2 prior DUIs. Because in California, when you get a motor vehicle record, it is a snapshot of 10 years of that employee's driving record. So had they in 2007, 2008, or 2009 pulled his record, they would have seen both DUIs. They would have seen that suspended license. And not only by their own policy, but by just common sense, they would have stopped that Delgado from driving their vehicle. And by not allowing him to drive that vehicle, they would have taken away the method and the mode by which he hit Elvira Gomez and caused her death. This death was eminently preventable by Xerox.